Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there a proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
Yeah, have you read that statute?
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says a demand for possession or payment shall be in writing addressed to the person in possession and shall give the address or other brief. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it. Good morning. The 14B District Court is now in session. My name is Elaine Washington.
I find everyone's very funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anise Battle, appearing especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct.
Here's a legal issue hiding inside the drama. Self-defense is not magic language. A court needs facts. Was there a weapon? Who had it? Who escalated the encounter? The judge isn't deciding guilt right now, but when someone asks for bond reduction in a violent case, the details matter.
Thank you. All right. Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that
Right away, the defendant tries to control the courtroom with legal-sounding language. Special appearance, not general. That may sound impressive, but judges see this all the time. In eviction court, magic words do not erase jurisdiction, rent obligations, or a signed lease. The real question is simple. Did she owe rent? And did the landlord follow the proper process?
her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Well, whatever you're using as your basis is still not correct. It is not the law.
It is. It's still under MCL and it's under the Landlord-Tenant Act.
Overruled.
My objection is overruled, Your Honor.
So the objection is sustained. Her question that cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was rescinded?
That's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there a proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL, what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
Yeah, have you read that statute?
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop talking. It says, a demand for possession or payment shall be in writing addressed to the person in possession and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there a proof of service of it on the record?
That's a different question though. So, okay, go ahead.
Yeah, but that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession,
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add, her question next is there proof?
Do you
No.
have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection. I just said MCL
Objection
because
is
they're
the-
both under MCLs. Both proof of service and certificate of service are both under MCL.
No,
All right, well, everybody, so
You,
let's not make my ruling.
let's just, okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
okay,
is
answer that question.
not on the
This is where the judge calls out the biggest problem. She is using pieces of old legal theory, common law language, and even references like the Magna Carta to fight a modern landlord-tenant case. That creates drama, but it does not create a valid defense. Courtrooms run on current statutes, rules, and evidence, not internet legal scripts.
disposition. And just like she read on 657-16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of.